Good day, colleagues. My name is Marcus Dekenaar, and I'm co-chair of the Load Research chapter. Our presentation today is on the Protection of Personal Information Act. All load researchers, modelers, and planners have at some stage dealt with sensitive data from or about customers. Today we have Ross Saunders, who is an evangelist on protection of personal information, to give us the latest on the POPI Act. Legislation on the Protection of Personal Information Act started arriving in South Africa in 2013 and seek to ensure that all South African institutions conduct themselves in a responsible manner when collecting, processing and storing information. Ross has got a Master's in Management of Technology and Innovation and is an EC Council certified ethical hacker. Ross is a global privacy and cyber security specialist who works with companies to grow their client base through a combination of technology, trust, and compliance. As an international speaker and advisor, Ross works to demystify technical security and legal topics to make them accessible at all levels of the organization. So without further ado, I hand you over to Ross. Ross, the floor is yours.
Okay, so we are going to talk about the Protection of Personal Information Act, or POPIA, as they're wanting to call it now. So rumor has it they didn't like the abbreviation of POPI, it now should be POPIA. So we're going to go into a bit of this act and also how it ties into research and things like that, because there are some different nuances when it comes to research and these data protection regulations. So we're going to dive into a bit of that, a bit about my background as well. So thanks, Marcus, for the intro. I have been in the tech space for the better part of 20 years now. And, you know, the last 10 years of that have been involved in various aspects in cybersecurity, privacy, that side of things. In 2013, when POPI started coming onto the scene, I started getting involved in the privacy side. And now in 2018, when GDPR in Europe came in place, which is Europe's data protection regulation, I've really been absolutely engrossed in it. So working through call centers, working through software support, working through risk management, through internal audit, those are the spaces I've come through as far as data protection is concerned. So cybersecurity, information security, personal information, all of these words that I'm throwing up in the air. But I think one of the things we need to go through, first things first, is get a couple of these definitions down, because there are a whole bunch of definitions of security and privacy and infosec and all of this, and they tend to sort of mold into each other, and that doesn't help anyone. So let's get into a couple of definitions here. The first one I want to go into, if my clicker decides to work, there we go, is personal information. Now, the definition I've taken for personal information here is from the Australian Privacy Act, simply because the Australian Act has a really nice, tight definition of what constitutes personal information. And personal information applies across different jurisdictions. You've heard me speak about Europe now, and Australia, South Africa, Botswana, Argentina, Canada, USA. Everyone is getting these data protection laws in place, though the USA is really the Wild West when it comes to data protection. So first things first on personal information. Personal information is information or an opinion, including information or an opinion forming part of a database, whether true or not, and whether recorded in a material form or not, about an individual whose identity is apparent or can reasonably be ascertained from the information or an opinion. So nice tight little description for you, but a couple of the key things I want to bring in here is particularly where it says whether true or not, because something can be personal even if it is false or satire or something like that. It can identify someone. And the other part I want to bring in here is where we talk about the identity being apparent or can reasonably be ascertained. A lot of what we try and do, particularly when we're doing surveys and things like that, and I know from when I did my master's and the surveys involved there, you've got these ethical guidelines to abide by. And you go via anonymization and things like that, and everyone will remain anonymous. But it's not necessarily that case, because you can use additional information to identify someone after they have been anonymized. So you want to look out for that. So where we talk about an identity that can be reasonably ascertained, we're talking about combining it with other information to see if we can build a profile. For a very simple example, if you think of downloading a bunch of information off LinkedIn, I can download people's profiles from LinkedIn, and then to anonymize it, I'm going to remove their names and I'm just going to leave their job titles. But say I forget to remove an email address, and then you've got that domain at the end of the email address. Suddenly I can identify the company from that domain. I know the position that the person's in. I can go back to LinkedIn and re-identify that person, because there's only one person in that position. So where we talk about reasonably ascertain information, it means that we can use public means to re-identify someone. It's very important to keep that in mind. Another little note I want to make here, and we'll touch on it a bit later as well, is where we talk about opinions. So opinions can also be personal information. So keep that in mind when we talk about surveys and things like that. Right, so that's personal information. Let's jump into data privacy. Now, data privacy is often confused with cybersecurity, and I want to kind of draw that line right now so we can get it in place that data privacy and InfoSec are two different sides. So if we look at the definition of data privacy, we're talking about the relationship between the collection and dissemination of data, technology, the public expectation of privacy, and the legal and political issues surrounding them. We have a tendency to say that data privacy must either belong in the compliance department or in the IT department. That's kind of where we dump the two of them. And that is not where we should be dumping them. If we look at this definition, we're talking about data, we're talking about technology, and then we're talking about public expectations. So we're now looking at PR, we're looking at marketing, we're looking at relationships with clients, and we talk about legal and political issues. That's also PR, but it's the legal department. It's now high-level management, it's engagement. So this sort of spreads across the whole organization, the whole association. Anywhere you're working, data privacy is very, very broad. And we don't want to bring it into being just ring-fenced into IT or compliance. Now compare this with information security, and this is a definition I need a breath for. Information security refers to the processes and methodologies which are designed and implemented to protect print, electronic, or any other form of confidential, private, and sensitive information or data from unauthorized access, use, misuse, disclosure, destruction, modification, or disruption. And now I can breathe again. This is very much tying in to the IT space and the security space. So we're talking about processes, we're talking about methods, we're talking about protection. Information security much more sits in the audit, compliance, IT space. But it's important to note that this is not only talking about digital stuff. This is also talking about your physical paperwork, your filing, things that are sitting in filing cabinets, things like that. That is where information security comes into it. So it's while it's not privacy and dealing with those legal and political issues and PR issues, it is very much dealing with data that we use on an everyday basis. So the two are related. So just to pop these into a bit of a graphic to make it a bit easier, and just to summarize the two side by side. If we look at privacy, we're talking about data that belongs to people, and you'll hear me perhaps talking about data subjects. Data subjects are the people that data belongs to. It's our respondents on surveys, things like that. We then talk about the tech. This is what we are using to collect the data, where we are storing data, what technology are we using. Tech can also be a filing cabinet or a credenza or something like that. It's the storage mechanism for the data. We talk about the public expectation of privacy. So if I give you my information in a survey, I expect as the public that you're not going to share that information with someone else. And then we talk about the legal side, which is there's a repercussion if that information is shared out without my knowledge or consent or without a contractual obligation. I have some sort of recourse that I can go on. Whereas if we compare that now to information security, we're talking about processes, methods, and protection of that data. Right. Everyone with me so far? I hope so. I can't see any videos, so I'm just going to barrel along. So let's take you through a little bit of a story. And Marcus alluded to the fact that I've seen a couple of things here and there along the way. Now, a number of years ago, I was working in the financial services space, and we were doing development and reporting on some Fortune 100 companies overseas and dealing on massive, massive data sets. So when I talk about a big data set, one of the tables that we were working on was about 6 terabytes in size. So it was huge, huge sets of data. And we had systems dedicated to it. We had servers dedicated to it. And the general way that we would work is we would start this report off on a Friday evening close of business. And generally by about Thursday evening, Friday morning, the report will have run, and then we can do the changes that we needed to the following Friday. So we got this all in place, ran it, and then one day we came in and we were waiting for the report. And, 8 o'clock came, no report, so could still be busy. 8:30 came, still no report. Probably still busy, let's have another cup of coffee. So I sipped on coffee, then 9 o'clock came, no report. 9:30, okay, maybe there's a problem. So we figured, the server's down or something like that. And to give you an idea of the layout of the building quickly, for some context, is the server room that we were in is on the 2nd floor of the building behind access control, which now is behind the development office, which is behind another access control, which was behind the professional services office, which was behind access control. And below that was reception, which was access control, and the entire office park had access control. So everything was very, very controlled, as you would like data to have. So this report wasn't running, and I decided to go into the server room. Now, as much as I'd like to say that the server room looked as nice as this slide, server rooms don't generally look this good, unfortunately. Instead, it's more clinical and white floors, white ceilings, and the buzz of air conditioning. So moseyed on into the server room, took a look across at the server, and lo and behold, one of the network storage devices had had a tray removed and a drive was missing. Which, not too much of a concern given the security I've told you about. It's not where you go that this was a security issue. It's probably just an IT issue because, a drive has failed or something like that. IT must be managing it. So trundled downstairs through the dev office, through the professional services office, through reception, down to the next building, got to IT, asked them, guys, what has happened with this drive? Why is there a drive removed? This interrupted what we were doing. And we got met with the standard IT answer, have you logged a ticket? So the answer was no, we haven't logged the ticket. And then it was a case of, okay, well, they didn't touch it. Still not the end of the world. We have a development team that would work on these servers, so perhaps they'd done something on this. Back up through reception, through professional services, down through development, get to the dev team. Guys, who's removed this drive? No one's removed the drive. And that's when you get this fantastic expression which explains what goes through your mind when you realize that this drive has been stolen or gone missing somehow. And that expression is because, man, it's scary. So we have now lost a few terabytes of data for a Fortune 100 company. What do we do? Well, first step is to get forensics in. So we got the forensics team in and going through all the logs, and because of issues with the way Hyper-V deals with devices being disconnected, no one saw the drive was removed. And we only noticed that the drive was removed the Saturday prior. So we'd had a whole week where this time had gone by. So the drive was removed, and we couldn't figure out, well, why would someone have removed it on a Saturday afternoon? No one was really working on a Saturday afternoon. And then it came through with the building logs. We had air conditioning teams working on the air conditioning in the server room at that time. And what had happened is while the air conditioners were being serviced and someone was in front of the camera system in the server room, someone else in the server room disconnected the drive and took it with them. And this was terabytes of data that had now just literally walked out the door through all the access control. And when we spoke to the forensics guys, what came out from this, which was chilling, was that there are syndicates that operate around the world for data. And what they do is they speak to guys that are working in cabling, that are working in networking, that are doing air conditioning, all these roles that get you into secure spaces in buildings. And they offer them, we will give you 200 Rand for every device that you can bring us from a desk, or every device out of a server room, or something like that. So these guys go in and then take these devices. Now, 200 Rand is not a massive incentive to commit a crime. But what happens is, if that data on that drive is usable and the syndicate can ransom it off from a company or from individuals or from associations or anything like that, then the person who took that drive gets 10% of that extortion money. Now, 10% of 500,000 Rand, 5 million Rand, is a lot more attractive than 200 Rand. And make no mistake, this is not like American movies where we don't negotiate with terrorists. Ransoms work, and people, the hackers, will give your data back in most cases after the ransoms happened, because if they didn't, no one would pay the ransoms, and companies wouldn't pay the ransoms if data didn't come back. And it's this almost economy that's now working in this black market data side. So this is how the syndicates were operating, and it's quite terrifying. Now, this was not without its cost, and we were lucky because we had an encrypted drive. The server, basically what would have happened is, removing that drive, the data would have been corrupted, which was a relief, let me tell you. However, there were phenomenal costs in this. And this is what I want to highlight, is just how a data breach can escalate in costs. So the first was the cost in time. With that investigation, we lost 2 weeks worth of work on these reportings, on the products that we were developing, things like that. 2 weeks down the tubes, gone. So we lost that. That's one thing, just salaries and all of that. The next cost was the investigation. The forensic investigation into this one drive that went missing came to 360,000 Rand. So that was quite astounding, and not many companies like footing that bill to be told that, well, you're in the clear, nothing was wrong, but we need to be paid 360 grand. But the last part, and probably the worst part, was the drama that came with it, and the absolute reputational damage and things like that. Because even though the data was not usable afterwards, it couldn't be extorted or anything like that, the problem was that we were developing this with a partner. We had the client as well. We had to inform everyone. The partnership was dissolved, so the entire development of the stuff stood still and got stopped because that partnership went away. The client walked away, so that was millions of rands lost with the client leaving. And the ultimate drama was that, we started losing staff. The project was canned, the product was canned, and what happens when products are canned? People get canned too, which is really not a great situation. I mean, I developed, I think, a bit of a data PTSD after this because of all the stress that comes with it. I mean, to this day, if I hear that client's name, I get a little chill down my spine. So very, very scary stuff. Now, this happened a number of years ago. And this happened before we had things like POPI in place. Now, POPI, being the Protection of Personal Information Act, is an act whereby it gives guidance to companies, to individuals, to research organizations, to associations as to how to handle privacy. And it does this by means of 8 principles. Now, when we talk about a principle-based law, it works very differently to a law that perhaps works almost like a checklist, where if you do this, this, and this, you're compliant with the law. Data protection doesn't work that way. Sorry, I see Karen is not able to see the presentation. Can everyone confirm that they can see the presentation, or is it?
There was a disconnect, so a lost connection came back in. I see most of the other people have come in as well. But I can't see your presentation. I don't know. Is there a way that I can
I think on the top right, on the top right, there is a little icon with a person and an arrow. I think you can select a view there. I think you might be able to select presentation.
Okay, I don't see it.
Can't see.
Okay, I can't see that. Anyone else also a problem?
Looks like everyone is able to see.
Okay, if necessary, I'll just reconnect.
Okay, so sure. Okay, so like I was saying, if you've got these laws that are almost like a checklist, very easy, do this, 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 you comply. Whereas with principles, you get given a set of principles, And you need to prove how you're adhering to those principles, which makes it all the more difficult when it comes to these kinds of laws. So let's jump into some of the principles of POPI. And there's 8 principles, and you'll find that these principles are basically available in any privacy law that you go to in the world. These were designed by the OECD in the 80s, and they have been carried through from then. So they're very, very common to see. And the first one is accountability. Clicker, there we go. And accountability speaks to, as an organization, as a group, as a company, that you have supporting information to show that you are complying with the principles. So you would have things like your policies in place, you would have processes, you'd have procedures, you'd be doing impact assessments. And all of this serves as proof to say, look, this is the proof that we are complying with POPI and that we have got methods in place. We talk about privacy in our policies and processes. So that's where the accountability state comes in. The next one we have is processing limitation. And this ties into the next 2 principles, which is purpose specification and further limitation. Now, processing limitation says if we are going to, for example, do some marketing or some research, and we say, for this, we need your name, your surname, your phone number, and your postal address. We only take those pieces of information. We don't take more information than we need, because we only need that. The more data you keep as an organization, as a group, or anything like that, the higher your liability is as far as data protection is concerned. And I mean, we've got a habit of always collecting as much as possible in case we need it later. That is very dangerous under POPI. You don't want to be doing that. Next, we have purpose specification, and that means exactly what it says there. Is we say what we're going to use this for. So we've collected name, surname, email address, postal address, and we say we are collecting these for research in this space. That is specifying our purpose. And that ties in then to the further limitation, where we say, this was our purpose, this is the amount of information we're collecting, we're not going to use it for anything else. Now, as researchers, POPI has a number of exceptions to things like consent, to things like data retention periods, and we'll get into both of those in a moment. But if you change your purpose or you share that information outside of the research that you were doing, then suddenly those exceptions no longer apply, which is a very dangerous caveat to be aware of if you do make changes to data or make changes to research or hand something over. But we'll get into some examples of those in a moment. Right, next principle we have is information quality. Now, information quality speaks to having up-to-date information. Honda in the UK got into a whole heap of trouble because when GDPR came in, it brought in the concept of opt-in as opposed to opt-out. We're in South Africa, we're used to opt-out. Overseas, previously, before GDPR, it was opt-out. And what that means is if you add someone to a newsletter or something, as long as you had unsubscribe at the bottom, it was fine. People could leave your newsletter, they could opt out of it, and you were fine legally. What POPI is doing, what GDPR is doing, all of these things is it suddenly becomes opt-in. So now you can't just add someone to a list. You can approach them once and say, do you want to be on this list? And if they say no, it's no. If they don't respond, it's no. The only time it counts is as a yes is if they say yes and they accept it. So it's flipping the script a little bit there, and that's what happened with GDPR. So Honda decided they're going to comply with GDPR. We're going to send out a mailer to all our subscribers and say, do you still want to be subscribed to us? The trouble is they sent this notification to a list that was 2 months old. So what happened was they sent the list out to tens of thousands of people, and a number of those people, a couple of thousand, I think, had already unsubscribed from the list that was newer. So now they'd already contradicted themselves on that opt-out list by mailing people who'd opted out already, and they got fined tens of thousands of pounds just for trying to comply with the law. And that all could have been avoided if they looked at the information quality aspect. So make sure your info is up to date. The next thing we look at is openness. Openness speaks to the fact that we are being open with what we're doing. We're transparent. We're collecting your information for this purpose, for this research, for this system, And we're only collecting it for this. We're only taking this much info, and that's what we're doing. And it's being honest. It's being transparent. So that's the openness principle. Very good. Not too much else to say there. Then we have security safeguards. And this is where we spoke about information security. Now, this highlights, I think, the fact that this is not the IT or the compliance department's problem, because security safeguards forms 1/8 of these principles. Yes, it's a really big one, and it's weighted heavier than the rest of these, but it is only 1 of 8. So security safeguards, this is making sure you have firewalls. This is making sure that data is encrypted if needs be. This is making sure that you've got locks on filing cabinets, that you have an alarm system. All those things count as security safeguards towards data. And then lastly, principle-wise, we have subject participation. And this is talking about people have the opportunity to take part, update information, change information, things like that. Now, if you think about the likes of a Discovery or Liberty or Momentum or something like that, they do this really, really well. And they combine subject participation with information quality. And take Vitality, for example. Vitality says, okay, if you complete your Vitality age and update your information there, we'll give you 5,000 Vitality points or something like that. So effectively what they're doing is they're incentivizing people to participate. So they are now data subjects participating. And they're participating by updating their information and keeping that information quality aspect done. So it's really quite cool how they do it. And they sort of nail both of those principles in one go. So these are the 8. Now, if you look at these, they're not that scary. Tell me I'm wrong here, but don't these just look like doing good business practice? You're being open and honest. You're being accountable. You're not taking more than you need. You've got quality information. You've got security safeguards in place. It really is just good business practice. So if you're following these principles and you ask the questions to yourself, okay, with this information that I've received, am I accountable? Yes. Am I limiting the processing? No. There we go. We're falling short of the law. So it's a very nice little litmus test that you can do as to what you're doing. Just asking each one of these as a question. Right. Now, one of the things that comes up from this, and we've gone through the definition of personal information, but how do you classify that it is actually personal information in terms of the law? And there's a nice little flowchart that we can use here. So first of all, if we ask, is it personal information? We need to ask, does it relate to a person? And in South Africa, this is a key concept because POPI, unlike most laws for data protection globally, POPI looks out for juristic persons. So things like trusts, companies, organizations, all of those have information that classify as personal information. It's not just about physical human beings, but we'll get back to that in a moment. So if we're looking at personal information when it relates to a person, the next question you have to ask is that person alive? Because if they've shuffled off the mortal coil, POPI doesn't really see them as having personal information. Now, that's not to say they don't have personal information or confidential information. A lot of estates would very much beg to differ with you, but when it comes to personal information in terms of the POPI Act, if someone has passed on, it's not seen as personal information. Then, can you identify them? If you can identify the person, remember we spoke in the beginning about things like bringing it back to LinkedIn or being able to search for someone in a public database. If any of that can tie back to someone and identify them, and they're based in South Africa, which is the next question, then POPI Act applies. So even though there are exceptions to things like research and all of that, the law still applies, and we'll get into examples of that in the next couple of slides. Now, going back to what I said earlier about the companies and juristic persons, again, the same questions apply. So if the personal information applies to a company, a trust, anything like that, and it is personal, and it identifies that company, it is seen as personal information in terms of the Act, providing that company is based in South Africa. Now, just as an interesting side note, we have the GDPR in Europe. When it comes to personal information under GDPR, it actually applies outside of South Africa, outside of Europe as well. So it's known as an extraterritorial scope. So that is something to be aware of if you ever do deal with Europe. But as I understand, we're mostly focused in the SADC region here. Right, so this brings us around just identifying that personal information. But then, as Marcus mentioned, and this is where we go deeper and deeper down the rabbit hole, there's different types of information that come in within personal information. So let's take a jump down the rabbit hole here. What is special personal information? Now, we talk about special information, we talk about sensitive information, we talk about confidential information. It's not all the same thing. So if we talk about confidential information, that is information that belongs to a company or something that cannot be leaked out. It's required by regulation or company policy that it has to say secret. It is secret information. So don't ever leak confidential information. That is company confidential, it's business confidential, things like that. Then we have sensitive information. And the general rule around sensitive information is sensitive information also relates to a business sense, but it's information that is recommended to not get out there. So it could be something that might have a reputational issue or something if that information is leaked. That is where we have sensitive information. Now we have special personal information. And this is where the POPI Act comes in. And this is any sort of information that can be used to discriminate against someone. It's a good way of looking at it. So the first thing out of this is we look at religious and philosophical beliefs. So if you are collecting information that denotes religion or philosophy or anything like that, that's seen as a special category of information. Similarly, if you've got race and ethnic origin, that too is special personal information. So if you think about BEE regulation here in SA and the Employment Equity Act, practically anything under that falls under the special personal information of the Act. Next, we have trade union membership. So any sort of trade union membership is also seen as special. We have political affiliation. So if someone has a affiliation with the DA or the ANC or the EFF, and we are collecting that, that too is special information. Medical information, sexual orientation, health information, any of this is special, as well as biometrics, so things like iris or fingerprint, and then lastly, any sort of criminal record information ties into special information as well. Now, what special information requires is generally a lot more consent, and people have to be explicit to say that, yes, you can process this information of mine, or it needs to be overruled by another act, much like Employment Equity Act. So we are processing racial information because of employment equity. And overall, you have to have additional protections in place. So this kind of information you might want to encrypt or put behind better security, or if it's paper-based, this is the kind of stuff that would end up in a strong room or a safe as opposed to just sitting in a cupboard or something like that. So you need to be sure of this kind of information is there. I see there is a question that's jumped in quickly and that relates very nicely to the last one. So personal information of a deceased person can be used to identify a person who is still alive. That would be personal information tying into the next person. So it does get very murky, but I would suggest treat most information as personal. The more we try and exclude certain information, the more difficult it actually becomes to protect, as opposed to trying to protect everything. So yes, if there's information about a deceased person that can identify a living person, that becomes tied together as well. Right. So as a researcher, as a planner, does this kind of stuff apply to you? And I would hazard it's a resounding yes, because this applies across the board. Like I said, even though there are exceptions, the Act is still applying with the exceptions within it. So let's go through a couple of examples that get used within the spaces that we're in. So first of all, let's talk about sharing spreadsheets. This is something that happens all the time. It's convenience. You know, let's just send an email off to someone and they'll have the information there. But as we're transmitting that information, we are now sharing it further apart and making that liability bigger. And we have to start asking ourselves, you know, if we share this information on, is this still part of our purpose that we were looking at originally? Are we staying within our limitation of data? Are we applying that further limitation and not using it for additional stuff? You've got to ask those questions to see whether sharing this information is actually allowed or not. The next part that this ties into is retention of data. Part of what you have to do under data protection law is you have to define a retention period. We talk about the data life cycle. So that's collection of data, processing of data, archiving of data, and then destruction of data. When destruction doesn't form part of that life cycle, the life cycle is not complete. And as researchers, you do have some exceptions here, because POPI will exempt you from some of the retention deletion sections if you can justify that this is for research and that no purpose is changing. And ideally, you want to anonymize that data when you're keeping it for longer. So even if it does go out, it's no longer identifiable. But there is an exception to the immediacy of getting rid of data if it's being used for statistics and research. But there are serious conditions around that, and we don't have enough case law yet either to define exactly what some of the rules and the nuances are there. So be very careful of that. Ideally, when your purposes have been fulfilled, you want to delete the data. You can collect it again if you need to do another purpose, or if you know there's another purpose coming, specify it up front, but you need to have that life cycle completing. Then let's talk about lost equipment. I spoke about a drive that was stolen. But think about this example. If we're driving around with our laptops in our boot, now you've got a whole bunch of information on your laptop. It's information stored in emails. It's information stored in your documents folder. It's information stored in 5 folders named to sort January, to sort February, to sort March, to sort April. And we have all this data glut everywhere. And that laptop goes missing out of our boot. Say we've stopped in at a BP and we want to go get a pie or something like that, and someone jams our remote and they take the laptop out. If you don't know whose information was on that laptop, according to the Act, you will need to notify the regulator and most likely the people involved who may have had information on that laptop to say that this information's gone missing. Now, if you think of the reputational damage and things like that, aside from fines and stuff that can be applied, it's phenomenal. So if you have a laptop stolen, there's no protection methods on it, and you don't know precisely whose information is on there, you've got to contact everyone and say, look, we lost data. And in the worst situations, you're going to have to take out like a spread in the Sunday Times or something saying, sorry, we lost your data. You might want to change passwords or something like that. So you've got to be very, very careful that those security safeguards are in place. And we'll touch on some quick wins on that in a moment. Next, we talk about toxic data. This is something I'm sure you guys would see in surveys. Toxic data is where people fill in the open-ended questions of surveys with personal information. So you need to be aware when you're collecting data, is there personal information coming into those free flow fields that could be used as personal info? I've seen things on SMS campaigns and stuff like that where people start sending through their credit card number by SMS as opposed to the reference number they were supposed to send. Now suddenly there's a credit card number sitting in data. Something to be very, very aware of, and to look when you're doing these things, what's coming in. Then we go on to smart metering, and the point I want to make on smart metering is something that comes out of data protection is that any sort of automated decision making needs additional protections in place. So if you're collecting information via smart meters and you're making a decision that can somehow affect someone's life, then that has to have additional protections and additional safeguards to make sure that there's places where people can object and where they can query this. Just making an absolute decision on something via an automated means, you really need to get consent and a lot more visible and what we call affirmative consent. It's consent that you have to be able to refer back to later. So it doesn't help to just tell someone this is what we're going to use and they say okay. You need to have it in writing or a recording of some sort. Now, we spoke about that special personal information, and if we are doing surveys and regional things, we are looking at demographics and LSM. This is going to be things that you really have to take care of. So LSM, you can start building profiles on people. Demographics, you can start building profiles on people. We spoke about in that definition that you can have aggregate information that you can combine. This is what happens here. So if you think back to that breach that happened about 2 years ago, the master deeds leak, where that information was unprotected on a server and it was everyone's ID numbers, LSMs, everything like that. That is all this aggregated information, and they collected that LSM data from other sources and IDs from this source and that source, and effectively that breach has breached basically every South African's information, which is just ridiculous, but that's what can come from collecting things like demographics. Be super careful when you've got this. Sharing and things like that, when it's not for the same purpose, the same research objective, it becomes very, very dangerous. And then lastly, that ties into our third-party sharing. You've got to be aware when your purpose changes. Yes, it's great to have all this data. If I hand that data over to someone else, is it for a different purpose? If it is for a different purpose, I am now in breach of POPI, as is the person collecting the data on the other side. So you need to be very, very clear. Take those 8 principles that I told you about, ask them as questions every time you're about to hand data over, and you'll be in a much safer place. So the last thing I want to say on third party as well is there's 2 approaches that you can use. One is anonymization. So if you are going to share it, you can make the data anonymous and share it across. But then you've got to be damn sure that it stays anonymous. If someone can re-identify that, that can put you in more trouble than you were in the first place because you've claimed it's anonymous and it's not. A better approach is something called pseudonymization. Say that 5 times fast. That is where you take information that you're going to share, anonymize that, and then you keep the identifiable information. So you're not saying it's anonymous to the regulator, but you're not providing the identifiable information to the third party. So there's a good negotiation that you can have there. Right. So does it apply to you? Absolutely yes. And now we get to the, if you're not scared already, now we're going to get to the scary part. This is the consequences. So there are a few consequences that come out of this. The first one is fines. That's the most obvious one and the most scary one that people are often like, oh, well, it's fines. Yes, it's fines. We know it's fines. Fines are sort of the least of your worries. Now, POPI, it's up to 10 million rand, but it is unlikely, and you're going to see in the media that people are going to be like, oh, it's 10 million rand fine straight off the bat. It's not. That's for guys that are just throwing data around, that aren't trying to follow the routes. The more you are protecting data and the more you can show that you're trying to protect data, the better the regulator is going to treat you because they can see you're trying to do stuff. And if you've got all this protection in place and it's just a fluke, you may get off with a warning or with them saying, okay, but we need you to implement these additional things in 6 months. So it's not, don't go crazy when you see in the media that it's 10 million fine or nothing. It's a sliding scale. Next, we talk about reputational damage. This can be worse than a fine. If you think about losing people's data and having to do that approach with a stolen laptop and approach everyone that you collected information from and say, look, we've lost your data potentially. Are you going to trust us again to do another survey? I'd hesitate not. So the reputational damage is bad. And in South Africa, one of, I think, 3 jurisdictions that I know of globally, so South Africa, Kenya, China, we have criminal proceedings for data loss. But this is more as well for when the regulator has told you 3 times you have to resolve this and you blatantly disregarded it, you're selling data, doing really dodgy stuff, then yes, there is provision for criminal charges against you as well as civil. And this can happen to the directors of an organization where data is going wrong. So you need to be aware, again, of that whole aspect that it's the entire company. So be very, very careful with that. Now, wrapping up quickly, what can you do about this? There are a few quick wins that I want to give you guys, and they're pretty simple to get yourself started on this. The first one relates to data, and that is get a map of your data and where it is. If you are storing people's data, make sure you've defined what folders you're storing them in so that you know if this laptop goes missing, oh, well, these folders were on that laptop, therefore these people's information was missing. You can limit that liability there. It also helps for you to know that, oh, we've got all this information, we haven't used this for 6 months, let's clear it. So map out your information that you're storing. Next, when we get to the tech side, there are a number of things you can do, but there are 2 phenomenal protections that you can put in place just as an individual. One is having a shredder. I've got a shredder sitting right down on the corner of my desk here. I lost my identity because someone threw away a payslip of mine in a company. And I have a tremendous fear of people throwing away paperwork. I don't throw any paperwork out of my household because it took me 2 years to get my credit record back. So have a shredder, shred paperwork that's no longer required. Don't just throw it out. The same syndicates that operate for drives and things like that go through rubbish bins. It's called dumpster diving, and it's finding paperwork and things in a dumpster. Shred it, you've got no worries. The other side, and this is the little padlock, is encrypt your data. If you've got Windows Professional, you can enable something called BitLocker on your laptop. It encrypts your machine. If you've got a Mac, you've got something called File Vault. So if you go into your preferences and settings for security, you can turn it on there. And then Windows Home, my consulting rates will be up at the end of this. No, just kidding. Windows Home, you have something called VeraCrypt. It's a third-party tool that you can download, and you can install it. It'll test your machine. It's not as friendly as BitLocker, but it's hell of a strong encryption. So you can look at VeraCrypt. Next, we spoke about that public expectation of privacy. Have agreements with people. Have your consents in writing. When you're doing a survey, things like that, be clear on what you're collecting this for. Go back again to those 8 principles. Have that all arranged with the people. Have those cleared when you're doing a survey or when you're sharing information, things like that. You want to be clear on that. And then on the legal side, those 8 principles, I'm going to reiterate it again, those 8 principles are such a key thing. You can do such a good gap analysis using those 8 principles as a question. Am I accountable? Am I doing purpose limitation? Am I doing further limitation? Do I have security safeguards? Am I being open? Have I got subject participation taken care of? You want those as questions, and then you've got a fantastic, fantastic gap analysis. And keep it in mind. Keep it front of mind. Get those gears turning. Keep it there for you. So, in closing, I have a challenge for everyone here, and it's in 2 parts. The first part is take one of the quick wins that I told you about and implement it. Just do one thing. The way you eat an elephant is 1 bite at a time. The next part of my challenge is to tell somebody about the quick wins that you've done. The more people do this, the more people have this around each other and they're aware of it, the better it becomes for everyone, and everyone becomes aware of data privacy. So folks, thank you. We are open for Q&A.
Thanks, Ross. I made a lot of notes out of this. I mean, this was very, very interesting and informative as well. So as you have pointed out, I'd like to just quickly open for questions, comments. Anyone? Marcus, you can go first.
Thanks, Mondi. As part of the Load Research chapter, we have, to a certain extent, been blessed with going through this process already, viewing the private information that we collected for research purposes and how it was treated. And we got to the point where a version of the data was placed in limited public hands, and it had been anonymized. So it was a very interesting exercise for us. On the other side of the coin, we just heard recently about the credit card driver's licenses and the fact that one of the laptops which had control over the security on those credit card licenses was stolen. And it seems like they're now in the process of reissuing pretty much all the driver's licenses for South Africa. So a very stark comparison there. Any comments from your side, Ross?
It's so interesting to me the amount of times that this really critical information can go out. And you know, that's a double whammy from what I was saying earlier about you. I mean, you've got that confidential information as well as your personal information. This is confidential information that's gone out that is likely to unlock a whole lot of personal information. And you know, if you look at what's on my slide at the moment, a QR code, a barcode, that's all data that's inside there. If you look at the new South African ID cards, those are near-field communications. If you tap those on a scanner, actually register that there's a chip inside there. So there really is data everywhere, and it's so important that that security safeguard principle is adhered to. And again, in that data map, you would look at, like, this is mission critical stuff for us. This laptop should not move. The US has had the same thing where someone high up in the military went over to China, to Beijing for a holiday with his Department of Defense laptop, which got stolen there. So it definitely happens, but it's so much a failure of control. You need to have those controls in place for that.
Perhaps just a follow-up question on that. If you you are keeping this data and you are found to have been incompliant in terms of all those, the security, etc., what could happen? Can you be charged? Can you go to jail for that? What could happen to you?
If you've like blatantly ignored all of this stuff. So the regulator doesn't accept ignorance as an argument. So in order to get the massive fines and criminal charges, you basically have to have done some really nasty stuff with data. If you are trying and there's a failure of controls and there's a data breach, they will take that into account. It's case by case. So if you're trying, there's been a failure of controls, you might get a small fine and a recommendation of what to do going forward from the regulator. If it's a massive breach where you've just shown negligence, that's a different story, and you're likely to get a bigger fine there.
Yeah. Colleagues, more questions?
Mondi, yes, I have one. There is an issue which is sometimes used to try to dislocate the law, and that's, law applies to nations and places. But when we come to cloud storage, that is kind of an interesting issue because a South African can store information in the cloud, which is probably going to be a server in Texas somewhere in a warehouse full of computers.
Not necessarily. But I'll carry on, and then I'll jump in.
I amend my question, possibly. And then part two for us. So, the question is, does cloud storage dislocate the law or not? And then part two is, if you could touch perhaps, Ross, on, the whole idea of smart metering and the use of AI for smart metering is that it allows potentially huge value to be generated semi-automatically in the industry that can benefit users or possibly the other way. But what I'm hearing is there are not necessarily controls in place at the moment for the processing of smart metering data in the industry. Over to you, Ross.
To answer your first question about moving into the cloud and being in breach of data protection, the answer is a resounding, it depends. So what happens with a lot of the cloud stuff, and we have GDPR to thank for a lot of this, Europe's data laws, is because the GDPR is extraterritorial and applies outside of Europe, it means that American companies, South African companies, Zambian companies, Malaysia, wherever, if they want to process European data, they have to adhere to GDPR. So what that has done is it's really changed the global legal landscape as far as data movement is, and we call them cross-border transfers, because now anyone who wants to do business with Europe has to comply with Europe's data protection laws, which from a cloud point of view are stricter than POPI. Now, what most of the data privacy laws do is they have a provision for transferring data across borders because we're going to. But what they will generally say is that the place that you are transferring the data to needs to have the same or stricter privacy laws. Now, if you want to get very finicky and go down to the letter, you can actually almost, technically the situation we're in now is if we transfer data to Europe, it's illegal for us to bring it back, because South Africa doesn't have a law that's strong enough in terms of Europe's views. But that's really splitting hairs. But if we're storing information from South Africa, and generally anything stored in the Europe, Middle East, Africa region, or any services offered to EMEA will be coming out of Ireland or the EU. So generally any cloud storage that's used for us will be based in Ireland, particularly if it's Microsoft or Google. And that takes care of a lot of the privacy concerns because they are so much stronger of a privacy law. You do have trouble if you transfer to the US because the US, like I said, is the Wild West. They have laws coming in now which is what we would have been proud of prior to POPI in some states. It's crazy. There's no federal law. And that's because I think privacy and the PATRIOT Act kind of contradict each other. So there's my long it depends answer on that. As far as it goes on the smart metering, there is phenomenal capability of AI and machine learning to do wonderful things for us. But the privacy laws are recognizing that there are risks to it, particularly GDPR. GDPR has entire sections dedicated to automated processing and that kind of thing. And I think if we follow those rules and put in safeguards, we're in a better place. But we'll see that those are going to have to come in when POPI comes in place.
Ross, thanks for joining us today to give us this very detailed and informative presentation. I think this is the first view that many of us have had of the POPI Act. Once again, thanks for your efforts, and we hope to see you again.